All right, Boris wants us to start.
Yeah, I'm assuming at noon, right?
Okay, we're live now. Hi, everyone. Good morning, good afternoon, welcome. I'm Senior Counsel here, Sang Kim here with Visa Nation, joined also by Managing Attorney and Partner Shilpa Malik.
Hi, everyone. Good morning. We are excited about answering your questions today. We'll try to get to as many of them as we can. So please bear with us. We want to be fair to everyone. But yes, we're ready to get started. So please start sharing your questions as soon as you're ready.
Okay, so while we're waiting for people to join and kind of start formulating their questions, we're happy to kind of just begin talking about some of the more current item news of the day. If the team could remove the landing image, we can go ahead and just focus the camera on Shilpa and myself as we begin the presentation. Thank you, team. So the big news probably coming up soon is the H-1B lottery registration for this year, as well as the news from USCIS that they will be planning to implement an online tool for employers. There was actually a engagement seminar yesterday, and there will be a second one today for the attorney representatives as well. But it's open to the public. If you go to uscis.com and look through the press releases and news alerts, you can see information about that. And I'm sure more information will be coming as the program is implemented. The second thing that's probably in discussion is the registration page for this year's lottery has not gone live yet. There is an expectation that there will be a change in the way the lottery registration is done this year versus last year. In particular, the big emphasis is probably that the fee will be substantially higher than the $10 it was last year. And in addition, there is, because of some unfortunate allegations and actions of fraud and misrepresentation regarding the lottery last year, one of the key core changes that is speculated to go live this year is that each beneficiary employee will have one lottery application per person. In other words, when the previous registrations were per position and per employer job offer and per H-1B position, this time it looks like USCIS is considering to lock in each applicant for one lottery registration per person. So that may or may not, it'll be interesting to see how USCIS plans to implement that if that goes live. And finally, the other big news is after some time over the course of the last year or so, USCIS looks to be finally ready to implement its very high and substantial fee increases for government filing fees across the board. Again, that that rulemaking process is in the final stages, but we're likely to see a final update on the fees within the next month or three. So with that said, let's see if we have some questions here. We have a first question regarding the L-1B visa. So let me go ahead and put this question live. If we can put that question onto the screen. The question is from what is the possibility of moving from L-1B visa to a green card? And there's a follow-up question on the chat is it possible to apply for a green card on family since my brother is a U.S. citizen? So let me start with the L-1B. I think the question raises a good point. It's a kind of a multi-part thing. The L-1B does not have a green card path the way the parallel L-1 visa, the L-1A manager does, in terms of a immediate green card availability under the L-1B category. Likely for L-1Bs, you will need to pursue the perm labor certification process, which is the most common green card process under employment-based categories. In other words, an employer will demonstrate through a three-step process before USCIS and Department of Labor that there is a need for this employee to fill a position that cannot be filled within the U.S. Easily. And if you sufficiently demonstrate that, you put yourself on a path towards a green card application. Regrettably, because there is a backlog for certain countries, because there's a finite amount of green cards every year, there is a severe an unworkable delay on the green card availability. In other words, many people who are under this perm green card process, which is only available for EB2 and EB3, are waiting 10 plus years, realistically. So when we speak to our peers and clients regarding the situation, the normal steps are an L1B person would move into an H1B position and utilize the I-140 under EB2 or EB3 for H1B extensions until the priority becomes current. And to the second question about family-based, the fact pattern was it was a brother. Unfortunately, brothers and siblings are a low category on the family-based side. So no, there won't be an immediate green card through that path either. But you may pursue that in parallel, and it'll just kind of be a seeing of whether or not the employment-based green card gets there first, or the family-based green card through your brother gets there first. Thank you so much. Let's move into screening the questions. Thank you so much for bringing the questions here. To put a kind of open disclaimer, we will not be answering any questions that are very fact specific and really directed and appropriate for a separate consultation. There are extenuating circumstances, there's nuances that really we cannot cover in this open office hours session. This is more for general questions and understandings about issues and points of interest that we may feel is helpful for the general audience. We will not be doing any sort of mini consultations today. So there looks like there's a question regarding the USCIS website. Okay, so this actually, yeah, we can talk about that. Yeah, so, thank you, Shilpa.
Yeah, you're welcome. Mikiko, so to answer your question, it can take up to 6 months to receive your green card. From what I understand, you came in on an EB1 and entered in September of 2023. I'm assuming you're talking about getting your legal permanent resident card from USCIS. But once you've entered the United States, USCIS can take anywhere between 30 days to 6 months to send out your green card. So it's not unusual for this delay. I would recommend that you wait until March. And if nothing happens, then you can possibly contact your local congressman or your state senator for a liaison with USCIS, and they should be able to get things moving for you. Other than that, Sang, do you have anything else to add?
Yeah, I will add that unfortunately the delay is experienced by many people. I would remind you to make sure that when you enter the U.S. in this category, you were stamped with what's supposed to be a 551 stamp that is proof of your permanent residency. And that should have an expiration date of at least a year for your entry date. If, so just be mindful that that is perfectly usable for work verification and status document. If you are getting to a few months before the expiration date, probably 3 to 6 months beforehand, set up a USCIS InfoPass appointment, go to your local office, and go ahead and get that stamped or raise that concern. They should be readily able to restamp your passport and even escalate the issue if you are still waiting for the physical green card. But yeah, you would probably want to make sure that the address listed with USCIS is correct. Use their chat features, use congressional liaisons, use this, the USCIS Ombudsman, OMBUDSMAN. They are a external agency affiliated with USCIS that acts like basically a watchdog or a compliance agent to help facilitate issues like your own, where USCIS is not acting in a reasonable or appropriate time frame. But thank you for that question, and we wish you well. Hope you get your green card soon. Let's go to
H1B. I'm not sure about the name of the app. The person's asking the question. Reaches 3-year expiration at the end of this year. Is extension by 1 year or 3 years? How to make 3-year extensions? Now, I'll quickly answer that question for you. Extensions are generally granted in 3-year increments, but it depends on whether your employer has enough proof to show that they have work. Actual H-1B work available for you for a 3-year period. If the employer is able to do that, they can ask for up to 3 years if this is your first extension. If you have an approved I-140 and your priority date is current, then you'll get a 1-year extension. But if you do not have an approved I-140 and you've not started the green card process yet, this will be your, and if this is your first extension, you can ask for up to 3 years at one go.
Thank you, Shilpa. I'm going to go and jump into a question regarding EB3. It's S's second question. It's the second question, team. Thank you. It's about general questions about EB3 and the timeline. So this is a good opportunity to kind of give a general understanding of prior dates, visa bulletins, progress. So I'm going to hit some big points here. Hopefully, this will all kind of connect together and give a context to what's going on and why the question can't really be answered. It's going to be basically a month by month prediction. So every year, the U.S. government has allotted about 240 green cards every year to be distributed among all possible applicants across all different categories of employment, family, special immigrants. Basically, there's dozens of different categories. And within each of those categories, that allotment is fixed for each country, which means every country gets the equal amount of every other country. So France gets an annual amount that is equal to India, equal to China, equal to Korea, equal to Canada. So if you think about that, that has been fixed for decades now. And so what occurs is a basic supply demand issue. If the demand of that country, of the people born in that country, exceeds the supply, they need to wait the next year when new numbers become available. And if the demand continues to increase and the supply stays the same, a backlog occurs. And that is what is unfortunately one of the biggest issues experiencing for legal professionals and our clients and related families and impacted people across the board regarding why there's such a frustrating issue regarding wait times for different nationalities and different categories and such. The backlog is real. The backlog it will require substantial help from Congress and the administration. It is not going to be fixed by legal briefs or jumping across categories. Unfortunately, it's a huge problem and it needs a huge solution. So, to the question here regarding the timeline getting approved. The fiscal year starts on October 1st of every year. It's based on the federal government. So at this point now, we are getting to the middle of the year, and essentially there is a expectation that once we basically get to the middle of the year, things won't really change because we've achieved a bit of an equilibrium as far as supply and demand, and USCIS kind of understands, working with the Department of State, how many green cards are going to be available. So unless there is a surge of availability or a usage of availability that suddenly drops or increases, those are the only ones to change the trend, as it were. For instance, if a lot of people are not using the green cards that are available to them, like take for instance during the pandemic when thousands and thousands of people were not able to come to the U.S. so they couldn't apply for the green cards, a sudden supply influx came in and lots of people were able to jump forward in line. But if the demand is the same outside the U.S. as it is inside the U.S., or there's actually a backlog of people grabbing it from years prior, then there's going to be less supply, which means that things aren't going to change. So with a lot of those factors, a lot of just guessing and predicting, and any person's guess is as good as mine, but I would say is that there's nothing to be done other than just kind of watching it month by month. And if there's something in the news that is on a global or national level, that may or may not be impactful, but there really isn't a way to kind of move or figure out or game the system, as it were, as far as the green card timeline. Thanks for everyone's patience on that. This comes up a lot. I just want to make sure we kind of address this big topic issue.
I also
Shilpa, do you want anything?
Yeah, I just wanted to add that a lot of people often come back to us with questions like, is a green card sort of eligibility or the country of chargeability based on country of birth or country of nationality? Please understand your country of birth and the country of nationality may be two different things or two different countries. For example, you could be born in, let's say, India, but you're now a Canadian citizen. That means that your country of chargeability is India and not Canada. While having a passport for Canada will make you eligible for other visas like TN or E2, so to speak. However, the green card eligibility will be still determined based on your country of birth, which is India, which has a much longer wait than for somebody who was born in Canada. So it's very, very important to understand that difference. Your country of passport or the passport that you hold, and if your country of birth are different, your country of birth rules in case of green card processing.
Yeah, and thank you, Shilpa, for reminding us about that. The other thing I want to add is the country of birth can also be utilized of your spouse if your spouse is born from a different country as well. So that is something that we've seen before, where the spouses are from different countries of origin and are able to leverage that towards a faster processing. Let's move to Ahmed's question. I'll just be very brief on this. Can I use the EB2 approval to apply for EB1? Would that increase the chance? I'm going to speculate here and just say that an EB1 is a completely different category, so you need to reapply for under that category with the evidence required. An EB2 approval by itself has no value towards an EB1 approval. So, as a blanket statement, no, it won't really improve the chances. Fact pattern wise, there might be something more specific about the EB2 that could be useful for the EB1, but that's not the question you're asking. Zahara, you're asking, what is the form number for reinstating a green card? If my presumption is that you've abandoned or you've relinquished your green card, or something happened and you want to reapply for legal permanent residence, regrettably, that means you have to reapply for green card all over again. So whether it was based on employment, whether it's based on family, as long as that eligibility remains the same, you can reapply for the 485 application. But there is no form or process to reactivate a green card that got denied or abandoned or relinquished. That is, unfortunately not a quick fix situation. You're going to have to get back into the line and start all over again. Hopefully it'll only take a couple of months, but depending on the situation, you may have to start whatever process all over again. Okay, I would invite anyone asking questions about legal services to please contact us through the consultation page on our website directly, as far as whether or not we handle certain legal services or not.
I would just like to answer Jake Gibson's question.
Yeah, that's what I'm saying.
I just wanted to make sure that you understand that immigration is federal law. So there's nothing called California spousal or fiancé visas, or Florida spousal or fiancé visa, or any other state for that matter. You can work with an attorney anywhere in the United States who specialize in immigration law. And I'll have one of the team members send you the information about the person you can reach out to. Thank you.
Thank you. Thank you, Shilpa. I'm going to, if I skipped your question, presume please that I will not be able to answer it on the info session today, and please reach out to us through our book a consultation page. Let's see, H1.
We can do the Shamant Gupta one.
Yeah, I think that's a good one. Yes, let's go ahead and put that live. So if an employee on H1 enrolls in a master's program, and I'm going to presume here that you understand this is a U.S. master's program, and changes status to F1, can they go back to H1 and decide to drop the master's course in the middle? So again, these are very fact pattern, but yes, it is permissible if you are still eligible for H1B and you still have H1B time left, because in H1B you are allotted a maximum of 6 years, sorry, apologies, 6 years in up to 3-year increments. Yes, you are permitted to change that. Now, the ability to change from H to F back to H is going to be dependent on a demonstration that you've maintained status and that you are eligible based on the employer to position to get an H1B approved in that category. So, but legally speaking, it is available for you to move from H to a different status and back to H again. Shilpa, did you want to add anything?
Yeah, no, I'm good with that. I think that was a very good answer and to the point, but that's all we can say at this point without having additional details. I think we can take on a question from Akshay Patil, who's raised about 2 or 3 questions. I can take a go at this one. How can I start my own business while being on H-1B visa? Now, please understand, these are very specific scenarios. H-1B is tied to an employer because they are the petitioners and you're expected to just work for that employer while you're on H-1B. Are there options to start your own business? Well, technically, you could open up an LLC and start a business as long as you are only a passive investor and are not actively involved in day-to-day operations and do not get paid a compensation by that business whatsoever for any work. Technically, you're not even allowed to perform any work. You're supposed to just passively sit back, let others run the company, and you continue working on your H-1B. So that's a short answer, and that's the best we can say at this point in time. To answer your other question, is concurrent H-1B visa an option? Again, if you're able to establish an employer-employee relationship with the second company, yes, a concurrent H-1B is always an option, as long as it's a legitimate, bona fide offer of employment and there's an employer-employee relationship. or a spouse on an H-4 EAD visa is a better option. To get to that question, if you are going to get an H-4 EAD, you'll have to, obviously let go of your H-1B status. And on an EAD, you can work for multiple employers. There's no restriction to the number of people or companies you can work for while on an EAD. That comes under the H-4 provisions. I hope that answers your question, but that's all we can provide at this time on this Q&A session.
Thanks, Shilpa. I'm going to jump ahead and move into the LinkedIn user comment from 9:09 a.m. It basically says, I'm currently on H-1B visa, which was picked in 2020. My employer hasn't started my I-140 process yet. In case I don't have an approval in hand, what's going to happen? So if I'm understanding the timeline here, you got H-1B in 2020, which means that if that is your first H-1B, you have 6 years of H-1B. So the sense is that you're going to be able to renew your H-1B until the 6-year maximum, plus or minus any other additional time you spend outside the U.S. Now, the issue is what you want to do is make sure that your employer moves forward enough through the PERM or I-140 process or both to have the approval before your final 6th year. So that's something you're going to discuss with your employer and legal team to make sure. Understand that from our experience, the PERM I-140 process is taking upwards of 2 to 3 years. So it's important to, at year 2024, to really engage in that conversation right now and be very realistic about whether or not, there's going to be meaningful movement on this. And if there isn't, to make your assessment based on that regarding what to do in a situation. Because if you exhaust your H-1B without an I-140, you'll have to exit the U.S. or change to a status that is available to you, and then reapply again under the lottery, or exit the U.S. for at least 1 year before reapplying for H-1B again.
Saying I'll take a question from Bolu Atife Adeo, but before I go into that, I wanted to remind everyone who's signed in that we're trying to get to as many questions as we can. We may not be able to get to all of them, so for that we apologize. We're trying to give everybody a fair amount of time, so please bear with us, and thank you for your patience. Would you recommend applying for my entire family, parents and brother at the same time? Would it delay any of the applications? They'll all live outside the U.S. I'm going to answer this question under the assumption that you are a U.S. citizen. Applying for your parents is a completely different process than applying for your brother. And when I talk about the process, the forms may be the same, but the time that it takes to get your parents to the U.S. is way less than what it would take for your brother and maybe his family into the United States. Your parents could come here in as little as 1.5 to 2 years, whereas your brother will have a wait period of 15 to 17 years. So there will not be a delay as such if you were decided to apply for all of them together. One application will not impact the other, but they have their own processing times, and your parents, being your immediate relatives, will get preference, and their application will be processed much, much faster. Thank you.
Thank you. I'll take LinkedIn user's comment at 9:10 a.m. What are the alternate options for unavailability of parents' birth certificate? I invite you to look at the Department of State's website regarding reciprocity on civil documents. They have a list of what they will consider acceptable if you are unable to get a birth certificate or non-availability. Having said that, as a practice, we find that under various circumstances, you can provide affidavits from family members, people who can attest to the birth of the individual and the circumstances, hospital records, school records. I would, the specifics will require legal consultation or preparation, but my sense, absent anything else, is that if you're going to do this on your own and you don't have what's required, provide what is available from a reasonable person's point of view, but USCIS website as well as Department of State have some resources and suggestions. But at the bottom of it all, if there is nothing else, an affidavit from from family members or friends, or frankly even for yourself, are sufficient to at least file it, and then see how USCIS will action it and come back to you regarding what additional action is appropriate to move the case forward.
Sang, I can take the next two from Julie and Joy.
Sure.
Julie, I understand you filed an I-751 petition to remove conditions and received a notice of extending. Yes, any period that you spend on that extension notice does count towards citizenship qualifications. Of course, there are other criteria that need to be satisfied to apply for citizenship. As long as you meet all of that criteria, as well as the physical presence and continuous residence requirements, you will be able to apply for citizenship. But your I-751 generally needs to be approved before USCIS approves your N-400 application. Now going on to Joy Tongo's application, I have a wet signature for an I-140 from a client that is 2 months old. Can I submit the application? If the client is still on board to submit the I-140 application at this time and you have written consent from them, then please feel free to use it. USCIS will not reject an application just because the signature was 2 months old. Typically within a 6-month window, USCIS is willing to accept the documentation. You just want to make sure with your client that they still want to submit this application, or would they like to sign the applications again? Sang, you can take on another one. Thank you.
Yeah, I'll take Wei Zhu's question. So this there's a lot to unpack here. I'm not going to answer this question per se because frankly I don't have enough information, but I do want to raise a couple things in here which I'm not sure if there's a misunderstanding about how the H-1B and the green card work in parallel. So to understand, H-1B provides status in the U.S. It provides status to live and work and travel, and that authorization is continuous until the expiration date or when the H-1B is exhausted. A green card process is a parallel track. So the green card process by itself, especially in the early stages, provides no benefit, and it doesn't really intersect with the H-1B as far as its status. In other words, you can be in H-1B status for up to 6 years and pursue green card during that 6-year period. At some point, if you're lucky, you will move from the H-1B to the green card process and move past the H-1B because now you are fully fixed into a path towards an approvable green card. As far as travel is permissible under an H-1B while a green card is application pending. There will be windows of time where travel would not be ideal because some filing requirements require physical presence, but those are very specific limited windows. And in addition to that, an H-1B and green card are compatible as far as intent. So you can pursue both in parallel at the same time. And at some point, you're going to want to move from H-1B to green card, or run them both. But at some point, the H-1B goes away, and then you move into the green card process. The final question that was asked here was, do we wait until the end of the period of H-1B? So this is very much in conjunction with the previous person who says, I got my H-1B in 2020. I don't have an I-140 approval. I'm going to run out of time in 2026. What should you do? And my answer to that was do it as soon as possible. My advice to employers on the call, as well as those who are having this conversation with your employer, it is always a good idea to start things as soon as possible based on how long these things take. When they start is a conversation you need to have with your sponsor. It is a lot of time, effort, and cost to move forward with that. Perhaps they need to make sure that this is a appropriate employer-employee relationship. Perhaps they need to make sure that their benefits is fair and you're going under the same timeline as everyone else. There's a myriad of reasons why people don't. Some of your friends or peers are starting a green card process on the first day to get their H-1B, and other people had to wait a couple of years or months before they were able to start it with the right employer. It's a benefits, it's a relationship question, it's an employer-employee question. It's not a legal question. My best legal advice is, if at all possible, start as soon as possible. Do not wait to the last minute. There's no value in waiting to the last minute. So I hope that answers the question and kind of gives general advice about how to navigate this conversation with your appropriate sponsor.
I can take the question from Sophia Borgogna. I'm sorry if I'm not getting your last name right. Just very quickly, this is a very personal decision to make. You need to obviously read the reviews about that law firm, see how you feel about, what's out there about them. You should contact somebody at that office, ask to speak with an attorney or schedule a consultation, and then, see how knowledgeable they seem about the specific visa process you need assistance with. And if you believe that they are the right law firm to represent you, that would be the time you'll make that decision. Now, in terms of, I know you've put in another question, can I hire an attorney even if I've applied for the I-129F? You absolutely can. If you haven't heard back from USCIS, then, depending on the timeline, it may be about a year, or it's taking anywhere between 12 to 14 months for them to process an I-129F. Sometimes it takes less, but that's the general timeline. If you receive an RFE, you need assistance, that may be a good time to engage an attorney. Or if your I-129F is approved and you need assistance with scheduling the K-1 visa interview, submitting the DS-160 form, as well as other supporting applications, that would also be a good time to engage an attorney. So it all depends on how comfortable you feel completing the process on your own, or you would rather have a professional who has years of experience in this handle that process for you. Now, the other question I would take is from, let me just pull it up.
I'll take the next question, Shilpa.
Okay, go ahead.
User 914 AM, can you pull that up, please? All right. So this is a moment for me to share another screen here. Team, can you share the screen here I have regarding the, thank you so much. So what I'm showing here now is the visa bulletin. I discussed earlier today about how long it's taking for certain categories and nationals and country of birth origin people to get their green cards. This monthly list from the Department of State basically outlines where people are in line towards, getting their green card approved. You'll note that some of these years, say 2019, 2017, and some of these wait times are very severe. So if the C is current, that means they're approving cases as they get them. If it's a date, that means depending on when you began the process, that's how long you're going to have to wait. So to the question regarding, I can't seem to understand what category to look at, this is your key. Unmarried sons and daughters, spouses, etc. That's how you reference this category. And then under here, this is how you reference the employment-based category. All the information is there. If you can't figure out your category based on that, then you're going to need to have a legal consultation, because something about your case is this disconnect. I hope this also answers Jim Abril's question regarding how to navigate the prior dates for his fiance visa. I will say is that there's two things you need to account for. One is whether or not the prior date is current. That's when you look at the Department of State website. And USCIS processing has their own separate pages for how long it's taking to approve the application. So both of those must be current, meaning your category must be current, as well as USCIS processing must be current. So I would say is that with anyone going to USCIS, use their chat feature, use their contact them on the phone to get a sense of what the processing times are. But it taking a year or so is not uncommon, unfortunately. I would say that anything that involves the embassy has a completely extra bit of processing expectations involved in that. Shilpa, is there any question you want to go through? We are at 9:30.
I can take
We'll be wrapping up soon.
LinkedIn user, which came in at 12:25. It says, hello, good morning, Shilpa and Sang. I'm an assistant professor in engineering. My EB-1B is ready to be filed. However, due to personal reasons, I'm leaving this university in May 2024. How does this affect my I-140 if approved? Technically, if your employer, is the one who's obviously submitting this EB-1B petition on your behalf, they have every right to revoke this I-140 within 6 months of you leaving, within 6 months of this petition being approved. So if it's ready to be filed, and let's say if they file it under premium processing and it gets approved hypothetically sometime in March, and you plan to leave in May, then they can revoke and it'll be of no use to you, because USCIS will see that this I-140 has been revoked. If you were to file a 485 concurrently with that, technically that would also be denied if your employer revokes this. So if you do have to leave the university in May of 2024 and there's no sort of reconsidering that decision or pushing that decision for at least 6 months from the time the I-140 is approved, then it's perhaps not the best idea to file the EB-1B through this university, since it would not really benefit you. On the other hand, if you're willing to stay with the university for another 6 months after the I-140 is approved, and if you can file your 485 concurrently, depending on what's your country of birth, then I would say there's value in it.
Akshay Patel at 921 or 1221 asked, can I get my H-1B visa stamped for extension 12.
Oh, sorry. My apologies. Go ahead.
Yeah, so there is a pilot program. It has very, very specific parameters. I would invite you to not. Our website has a breakdown of the requirements, but I invite you to look directly at the Department of State's website about the pilot program. You should be able to use any keywords to go to that website on any browser, and it will explain to you what limited windows and which what categories are available for that pilot program. Nash, I got my H-1B visa stamp last year. I'm in India. Okay, so I'm sorry about the situation. I would say basically is that if this is, you can reapply while you're abroad. That's the answer I can answer for this one. You as long as you can find any H-1B employer. However, if this was based on a lottery, and you were able to begin employment while in the lottery, then you're going to need to apply again for a new lottery application. We're skipping some questions here just because they are very fact specific. And at 12:35 p.m. Eastern Time, 9:35 Pacific. Just want to give a 5-minute heads up. We'll be concluding soon. We thank you so much for all these questions. We invite you, please, to contact us if you would like to, have a more in-depth conversation, especially if we're unable to answer your question here in the open hours. And we absolutely will plan on having more of these sessions in the future. We're very happy to see how attendance and these great questions. So looking forward to future engagements on this. But let's go ahead and see if we can answer any more questions before we wrap up today. Shilpa, is there anything that caught your eye that we can answer?
I wanted to sort of address Hormoz Hossein-Pour's question only because it's fairly common for people's application to go into administrative processing once they apply for any kind of visa. So the very fact that your application was moved to 221G is not uncommon, and 240 days, there's just no timeline in which the administrative processing is completed by the consulate or the embassy in question. There are extensive security clearances and background checks involved, and unless they get all the answers back, it can even take a year. We have had clients who waited for a year and a half, and there's been no answer, or it's just come in much later. There is no way to expedite the process. You're welcome to contact the consulate or embassy, but the only response, if any, you'll get from them is that your case is still under administrative processing and they do not have a timeline to give you. Administrative processing is generally not such a bad thing. It means that your case is generally approvable, but the consulate or the embassy needs further background information that you cannot necessarily provide, but through their own sources before the visa can be issued to you. Obviously, if they find that something is not satisfactory during when they get all this information back, they can still refuse your visa, but typically cases get put into administrative processing, which is called 221G, only because there is a chance of approvability pending information that they need from the sources that they're seeking the information from. Thank you.
Thank you. I'm going to take Sophia's quick question. Actually, to get answers. Sophia Borgonas, I apologize for the mispronunciation, at 9:25 or 12:25. Is it acceptable to commission a law firm after submitting petition Form I-21 to the U.S.? Sure. You can engage with a legal team or our team anytime you'd like. The question I think you want to be asking is what can be do with a case that's already been filed. The answer is probably not much. We'll probably have to wait to see what happens next after the case is filed. But if there's something that is concerning you as far as what you filed or as far as what possible next actions are, feel free to engage services with any legal provider, including ourselves. But there won't be any sort of follow-up action filing we can do until there's a appropriate junction point with the USCIS processing.
I'll take one final question from Monica Sanchez very quickly, and Sang, if you want to take one more, I'll leave it to you.
Yep.
We do have to wrap up the session. And again, thank you everyone for all your excellent questions. We truly appreciate it. We love sharing our knowledge with clients and are here to help you. You can reach out to us individually with specific questions. We're happy to answer them. But the question from Monica Sanchez is, if I get a green card through employer sponsor, is my green card conditional to keep me working for them? Or is there a time I must keep working with sponsor in order to keep the green card? Now, that's a question we actually come across quite a few times from existing clients or people who are looking to work with us. It is never, green card through employment is never conditional. However, there's clearly an expectation representation that you will work for the employer who sponsored you for at least some time after your green card is approved. Now, that period of time could be a month, it could be 6 months, it could be 6 years. It all depends on your circumstances. And why is that important? Because there is always an intent that's involved in these processes. There's an intent from your employer to engage you full-time for that position, whereas your intent is to work for them full-time once that green card is issued. If you basically get your green card and leave them the next day or never work for them, it raises a question in USCIS mind whether this filing was actually legitimate, or was it a misrepresentation on part of the employer or the employee, or both. And it can pose issues with citizenship applications in the future, where they go back and look at your entire immigration history, or even before, if some officer decides to just investigate and be like, has this employee ever worked for this employer? So is there a really a set period of time that you need to work for them after a green card? Not necessarily. It may not even be in your hands. You may be let go. The company may shut down. That position may no longer be available. There are hundreds of reasons why you could not. As long as you have a legitimate reason for leaving the company, no issues. But if you never work for them, or you work for them for a day or two after getting your green card, then you need to be very careful. Thank you.
Thank you, Shilpa. I'm going to answer one last question, not directly, but I'm going to give you some general understanding about grace periods, especially after on H-1B status. Naveen M's question around 9/27/12/27. After I quit my previous employer on H-1B, when will the 60-day grace period end? When a new employer files petition B, when a new employer is approved, when can I join? Okay, so very fact specific, won't answer that. What I'm going to explain is a general understanding of how the H-1B grace period works. So H-1B, like some other visas, have what's called a grace period, meaning that after the expiration event or denial event or some other event, some statuses provide a bit of time to wrap up your affairs and leave the U.S. Or change status if that's still available. Now, with an H-1B, hardwired into the regulations is that, because there's an understanding people move jobs, people get laid off, people quit, that if you quit or termed or laid off from your position on that day, the term date, the quit date, that's when the clock starts on the 60-day grace period. That's how one would calculate the 60-day grace period. Legal advisors will differ on how you might be able to work through that, but I'm going to explain to you what the intent of the regulations is, what's written in the regulations, and it's the final date of employment. Not pay statements, not anything else. It's a 60-day starts on that day. Now, within that 60-day grace period, you are allotted by USCIS to timely file a new H-1B with a new employer to transfer your employment. If you are able to file a viable H-1B within that 60-day grace period, you are permitted from an H-1B employer to a new H-1B employer under the portability regulations to begin work once that H-1B has been received by USCIS, usually a receipt notice or other confirmation as acceptable. This is a very specific question you're going to need to address with your employers and your legal teams for those employers. So, depending on the situation, there's a level of risk that may or may not be inherent. And based on that risk, that may indicate to you the appropriate action of when the start date is and whether or not it's appropriate to begin work, or whether or not you need to wait for the final approval decision. Just want to hopefully the questioner had found that information helpful, as well as others on the call. It is 9:42. I'm happy to have gone a little bit over. Thank you again for your questions. We look forward to engaging with you in the future, whether you contact us for a consultation, whether we see you in a future Q&A webinar. But we wish you well in the new year, and we hope all the best for everyone in their respective immigration journeys.
Thanks, Sang. Again, I wanted to thank you all for your excellent questions. We really appreciate you trusting us with those questions. And I'm sorry we couldn't get to all of them. As you can imagine, it's hard to get to so many questions, but we tried to do the best we could. And we hope to have more of these sessions, as Sang mentioned. In fact, at the end of this webinar, you will, we'll share a link on how to schedule consultations with the firm if you decide to do so. If not, we'll see you at a future Q&A webinar. Thanks again.
Thanks, Shiba. One last thing before we log off, just want to, the team is reminding me to encourage people to please follow our LinkedIn page for updates on future webinars and Q&A sessions, as well as other sorts of opportunities we have to engage current and future clients. Thank you again, and sign off and have a good day. Bye.
Bye. Thank you.